All right, we haven't touched on Paige Williams's article in the New Yorker on Kyle Rittenhouse in quite a while. If you remember, the title was Kyle Rittenhouse, American Vigilante. Oh, and everybody's saying so fair and so unbiased the way that she treated Kyle with kid gloves by calling him a vigilante. Okay, fine. If you buy into that, be my guest. Now, I've already done a whole bunch of videos on that article and have shown that Paige Williams was anything but unbiased. It was a hit piece, and I showed you why. Now I'm going to focus on a particular paragraph in the New Yorker article that deals with provocation. And the citation in here, the article that is cited, is actually quite good. It's a very good article. Unfortunately, Paige Williams decided not to cite the stuff that defended Kyle, but other things, and we'll see here in a minute what I'm talking about. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
Okay, so the paragraph begins, in Wisconsin, determining if someone acted in self-defense involves the question of who initiated the aggression. But as in many states, there is no clear definition of provocation. And so she's trying to make it look like, wow, man, if you go into Wisconsin statutes, you'll never figure out what provocation is. That's baloney. Let's take a look here. Wisconsin defines provocation quite well. This is from one of my past videos. It states here, a person who engages in unlawful conduct of a type likely to provoke others to attack him or her, and thereby does provoke an attack, is not entitled to claim the privilege of self-defense. It looks to me like provocation is pretty clear here. It is unlawful conduct, and it's likely to provoke others to attack. Okay? Now, Paige Williams, though, doesn't want to tell you this. She either doesn't understand Section 939.48, didn't read it, or she understands fully well and simply doesn't want to tell you about it. So let's go back. So she wants Wisconsin's provocation law to be murky. And why? Well, let's read. As John D. Moore explained in a 2013 article in the Brooklyn Law Review, in some parts of the country, a person forfeits the privilege of self-defense merely by having shown up at a foreseeably dangerous situation. And that is true in some parts of the country. In a lot of southern states, that is true. And I began to wonder, why is it that the southern states have this so much? For example, North Carolina. And I think it's because those states place a high emphasis on politeness. A true gentleman will always avoid conflict. And if you cause a problem, then you're to blame. Essentially, a true gentleman would never provoke somebody to attack him in the first place. And therefore, if he does, well, then he is to blame for what took place. But notice something. This is only in some parts of the country, and Paige Williams is leaving open the possibility that this might actually be Wisconsin's law. False. Wisconsin does not follow that prescription. And we'll see why here in a moment. Moore argued that the varying standards make it harder for citizens to fairly distinguish between the vigilant and the vigilante. So she likes to put that quote from Moore in there because why? It contains the words vigilant and vigilante. And she likes vigilante. If you can mention vigilante as often as you can, you do. Wisconsin's law favors someone who, in good faith, withdraws from the fight. And you would think it's over. Kyle Rittenhouse clearly withdrew from the fight, but she can't stop there because, again, That would make Kyle look innocent. So she ends the sentence by saying, "Yet there's not always a duty to retreat." Well, Kyle did retreat. Why does it matter whether there was a duty to retreat if he did in fact retreat? So the word "yet" is in there to make it look like, okay, yeah, Wisconsin's law favors someone who in good faith withdraws from the fight. Yet there is not always a duty to retreat, leaving the reader to think that, well, Kyle's not off the hook. At Rittenhouse's trial, which is scheduled to begin on November 1st, the jury may need to find only that when he pulled the trigger, he reasonably feared death or great bodily harm. Okay, so this is the article in question. Reasonable provocation. And I recommend reading this. This is a very good overview of how provocation changes from state to state. It's kind of long, so what I decided to do was sort of summarize it and structure it to where it's easy to follow. So essentially, there are three types of provocation that the author has identified by pouring through all of these different statutes that each of these states uses in its self-defense laws. And any provocation is one of those. So let's go ahead and read this. Any provocation. And by the way, I'm going to have to warn you up front, Wisconsin is not an any provocation state. So what I'm reading does not apply to Wisconsin, even though the anti-Kyles will desperately want it to. All right, let's read this. The any provocation frame places a heavy burden on individuals seeking to claim self-defense. Such individuals must not do anything they know might lead to trouble, let alone take affirmative steps to provoke the incident. So you can imagine why the anti-Kyles would love this. Kyle just simply showing up with his rifle in their mind would be enough to claim that he was provoking violence. Thus, provocation can mean little more than being somewhere an individual has reason to believe is the wrong place at the wrong time. How many times have we heard Kyle should not have been there? He should have been at home. He went into a dangerous area with his rifle. He should have known something was going to happen. While the language courts have employed has been described as an overstatement, various courts' application of the language indicates that it is still a remarkably broad standard. Okay, so let's read a couple of examples. Again, I cannot emphasize this enough. Wisconsin is not an any provocation state. So what these examples show does not pertain to Wisconsin. Okay, example. Even using a gun fatally to stop a robbery would not protect one's self-defense rights if the existence of the gun caused one to have to use it. In the instant case, okay, now what case are they talking about? There was a robbery in progress. I don't recall whether it was a liquor store or something, but a good citizen who was carrying a gun saw this robbery taking place and decided to try to stop it. So he stepped in, pulled a gun on one of the robbers. The robber turned his gun on him, and the good citizen opened fire, shooting the robber. So let's read the quote here. In the instant case, the record clearly reflects that the defendant approached an altercation that was already underway with a loaded weapon by his side. Such activity could be reasonably calculated to bring the difficulty that arose in this case. In other words, poor Slater, and that was the man's name, he ended up on the chopping block because he tried to stop a robbery with his gun, and because he had a gun with him, that's what forced the robber to try to train his weapon on Slater, and therefore Slater was to blame for what took place. Can you imagine living in such a state? In the state of South Carolina, I would be very hesitant to carry a gun. All right, let's take a look at example 2. And by the way, I should mention, I'll mention this again, I am not a lawyer, so don't take my word for these things. Read the article, and by all means, if you're going to get involved in anything that could hurt somebody, talk to a lawyer that understands self-defense laws in your particular state. Here's another example. Insulting someone to the point where they attack you, even with an illegal weapon, would not protect one's self-defense rights if the resulting fight resulted in death or serious bodily injury to the assailant. The court held that even though the victim had initiated the physical altercation, the defendant still could not claim self-defense because the necessity for such a defense arose from the defendant's own actions. A defendant who provokes an incident, even verbally, is precluded from asserting a valid claim of self-defense under the any provocation frame. What happened here? Some dude insulted another guy's father. The other guy's father was a cop. The dude went up and said that all cops are pigs or something of that order. Because of that insult, a gun was pulled on him. The defendant pulled out his gun in response and shot him. And the state of Virginia said, if you hadn't insulted this person's father, that person would not have been compelled to bring out his weapon on you, and you would not have needed to shoot him. And therefore, Scott lost. And he's probably breaking big rocks into little rocks today. So the any provocation is a dream requirement for the anti-Kyles. They fully believe that Kyle is to blame for anything that happened because his carrying of the rifle instigated a reaction. Keep in mind, Wisconsin, again, is not an any provocation state. The state provocation frame places a modest burden on individuals seeking to claim self-defense. Such individuals must not act as the aggressors in the conflict. The mere knowledge that one's presence may provoke a conflict is not enough to deny a claim of self-defense. Instead, an individual's presence only counts as provocation if it is deliberately calculated to lead to further conflict. This is the difference between reasonable belief and intention. Okay, so reasonable belief would be the any provocation frame. Intention is the straight provocation frame. Under this frame, individuals must intend to provoke a conflict before they are precluded from claiming self-defense. Merely having reason to believe that their actions will provoke conflict is not enough. Okay, so here's a couple of examples. Before an act may cause forfeiture of the fundamental right of self-defense, it must be willingly and knowingly calculated by the defendant to lead to conflict. One who merely does an act which affords an opportunity for conflict is not thereby precluded from claiming self-defense. And this is from the state of Arizona versus Jackson. Another example, when a defendant fired the first shot, he forfeited his right to self-defense when the victim fired back because the defendant had provoked the incident by firing the first shot. And this was a barroom fight that took place out in a parking lot. A man took a shot at another one and in return got shot at. He then turned his weapon and shot him dead and tried to claim self-defense. But the court said, no, your first shot at him was intended to provoke conflict. Here's another example. Breaking into someone's home forfeited the right of a defendant to claim self-defense when he was attacked by someone in the house. This involved a person who broke into a house late at night. And whose house was it? Well, it was his girlfriend's, and he suspected that she was shacking up with somebody that night. So he breaks in. The person sleeping with his girlfriend came out, I think, with like a hard object. I think it was like a baseball bat. Marquette, who was the guy who was breaking into the house, shot him dead. Provocation with intent. The provocation with intent frame places the lightest burden on individuals seeking to claim self-defense. Unlike the straight provocation frame, where the intent to provoke any confrontation eliminates the right to claim self-defense, the defendant must intend to provoke the victim for the purpose of doing serious harm. Example: defendant brought a gun into an apartment to force the victim to leave the premises. The victim left and brought a sawed-off shotgun, prompting the defendant to shoot him. Quote, even behavior that is provocative within the ordinary use of the word does not forfeit a defendant's right to claim self-defense so long as the defendant did not provoke the incident with the intent to cause death or serious bodily injury. In this case, Samuel 1, even though he brought a gun into an apartment to force the victim to leave the premises. The court ruled that his bringing the gun into the apartment was not intended to provoke the other for the purpose of doing serious harm to him. Here's another example. Defendant fired a gun at someone who robbed his friend earlier in the day. The victim returned fire, prompting the defendant to fatally shoot the alleged robber. The defendant lost his right to self-defense because his first shot was intended to kill or cause serious injury to the robber. And that is the state of Delaware versus White. Okay, so let's go ahead and summarize this. In any provocation jurisdiction, Wisconsin's not one of those. Merely being in a place where the individual has reason to think a punch will be thrown is enough to constitute provocation. In a straight provocation jurisdiction, the thrower of the first punch cannot claim self-defense after the second person hits back. In a provocation with intent jurisdiction, it is not even necessarily provocation within the meaning of the law to throw the first punch. Rather, the individual who throws that punch must have had the conscious object of instigating an altercation intended to cause the victim's death or serious bodily injury. Only in that exceptionally limited circumstance has the defendant provoked the subsequent response and forfeited his right to claim self-defense.